how to get the client to pay your attorney's fees if you have to sue the client for breach of contract, today on the podcast.
This is the Wedding Industry Law Podcast, a podcast dedicated to wedding professionals that are just trying to keep it legal. And now, your host, Rob Shank.
Hey out there, welcome back to the podcast. Super glad that you're joining me today. Really interesting, real contract-centric episode today. But before we get into the content, a couple things I got to ask. The first thing is, pretty please, if you could mosey on over to my YouTube channel at Wedding Industry Law and subscribe. Would really like to grow my subscriber base on YouTube. I would love to get to 1,000 subscribers because that way I can go live from my mobile phone. I am really enjoying YouTube's interface, so if you guys could help me out with that, that'd be great. Also, while you're on my YouTube channel, if you're watching this video there, like and subscribe, leave a comment. I love getting suggestions for content for the show. In fact, many of the episodes so far have been because someone has said, hey, I want you to talk about a certain thing, and I've done it. So leave a comment with whatever you want me to address in an upcoming episode. I promise I will get to it. I will not ignore you. It will get done. So those are my two calls to action. Please subscribe to the YouTube channel. And if you got any suggestions for content, let me know in the comment, or you can go to and hit me up on Instagram, in other words. So, okay, Instagram, YouTube. Now, let's get to it. Okay. Now, typically there is a concept in the law called the American rule. And it's the American rule. Who knows why it's the American rule versus any other rule other than we have this rule. Other people have it, but we get the namesake. Okay. So there's the American rule, which is to say that everybody that brings a case has to pay their own way. Both parties pay their own attorney's fees, meaning that if you sue somebody, even if you win, even if you're successful, you're going to have to pay your own attorney's fees. You will not get your attorney's fees paid for. And vice versa. If you lose the case that you bring, you will not be responsible for paying the victor's attorney's fees. That is the default American rule. And I say default because it's the default rule in most American courts. Okay. There are some exceptions to that, and we'll get to that in a second, but it's the general rule that everybody has to pay their own way if they're going to sue somebody, even if you win. And it's my understanding, we learned in law school, that one of the main reasons why this is the default rule is because it acts as a, not incentive, but it doesn't scare people away from bringing meritorious claims. So you're sitting there at your kitchen table and you're thinking to yourself, I really want to sue my employer for discrimination, or I want to sue them for back pay, or I want to sue my neighbor because of whatever. But in the back of my mind, if I'm thinking, man, if I lose, I'll have to also pay his attorney's fees. That would likely mean that you're probably not going to bring that lawsuit. And we would rather have people bring lawsuits and not have to worry about that, so that the court of law can hear more claims and adjudicate more matters. And the idea is that more justice will be dispensed by the courts, as opposed to there being some type of freeze on the people wanting to bring claims because they're scared that if they lose, they'll have to pay. So that's kind of the reason why that is the rule, that everybody kind of pays their own way, because we don't want to punish somebody for the right reasons bring a claim, but if they lose, they're like further punished. Not only do they not get anything, they got to pay the other side. So that's why we have it, and that's what it is. So there are a couple of exceptions to this rule pretty much in throughout all of the states. The first exception is going to be for egregious conduct, like conduct that's like, some states call it stubbornly litigious. Some states call it, abusive litigation, or whatever the case may be. But if someone's conduct is so bad that the judge is like, look, we wouldn't likely even be here today if you hadn't been such an a-hole. We wouldn't even be adjudicating this matter if you would have done what you should have done, XYZ. So in those instances in which there really isn't any question that the other party is being a bad egg, in some jurisdictions through statutes or case law, you can get the loser to pay your attorney's fees. So the first exception is typically very egregious conduct. Okay. The second exception is going to be statutory. There are some statutes that, depending on what the lawsuit is, you're going to get your attorney's fees if you are successful. And the example that I give for that is copyright. So if you sue somebody for copyright infringement and you in fact are successful, typically the statute allows you to recover attorney's fees from the other side. So not only do you get whatever damages that you were awarded in that case, you're also going to get the judge to say, yes, they owe you whatever you paid for attorney's fees. Those are the two general exceptions to the American rule that everybody's got to pay their own way: egregious conduct and some type of statutory loophole. And the statutory loopholes generally will not apply to wedding business law for the most part when we're talking about suing a client for breach of contract or for breach of some type of duty that they have in a contract with you. So if there is a bona fide dispute, if there is a good faith reason why the defense did what they did, then everybody will probably end up having to pay their own way. Okay. So, well, Rob, I don't want that. If I sue my client because they canceled the wedding and they won't pay me, or because they're being a bad egg, I want attorney's fees. I want them to have to pay my attorney's fees. Can I do that with my contract? The answer is absolutely you can. Yes, you can. People are allowed to contract around the American rule. People are allowed to contract around the American rule, the general default rule that everybody's got to pay their own ways. And most of your contracts that I see have some type of boilerplate provision in it regarding this. It usually says something like, if the vendor has to sue to enforce their rights, or if the vendor is successful in enforcing their rights in a court of law, or if the vendor is successful in suing the client for X, Y, and Z reason, the client will be responsible for attorney's fees, court costs, expenses. Okay. Typically it's something like that. Okay. So if you have that, fantastic. The issue here today, so not only do I want to educate you about the American rule and how we can contract around the general American rule, and you probably already had that in there, but the nugget, the golden nugget, if you will, of today's episode is your attorney's fees clause might not be adequate in most situations. So when I first started litigating cases, a decade ago, I guess, I don't know, I was just a young pup. Technically, I wasn't a young pup because I took some time off to be an idiot for several years, and I went back not as a traditional student to law school. But anyway, which is why I'm bald now. So, you have a client come in the door, and they're like, Rob, open and shut case. Let's sue these guys. Let's get some money. Okay, fantastic. We sue or whatever. And then all of a sudden you get the response to the litigation back, and there's like 18 counterclaims. You hit my dog, you stole my lunch money, blah, blah, blah. And you look at the client like, what's going on here? Well, it's not exactly like that. So in other words, typically, what does it mean to be successful in a case in which now not only you've sued, but maybe now you're a defendant? Maybe there's some claims against you. It's not so cut and dried what your attorney's fees clause says in your contract as it is right now, that boilerplate provision that says if you're successful and you sue. Because what does it mean to be successful in a case? So let's say that you get an award you sue the client for breach of contract, you get an award for $100. Okay. Is that successful? Is it successful if you were actually wanting the judge to give you $10,000? Some judges would say, no, you were not successful in this case, even though you got an award for $100. You were asking for $10,000. So in the times where there's counterclaims, it makes it even more muddy. And there's times where there is a legitimate claim against you, like who knows? So in a case where let's say that client owes you $1,000, okay? And you're saying lawsuit, boom, judge, I want $1,000 from this guy. The defendant's position, your client's position is that, okay, I owe you some money, but it's not $1,000. It's $200. Okay. So you're asking for $1,000. They're saying, no, I think that their fair amount under the law is $200. Okay. Are you successful under the contract term to get attorney's fees if you get a judgment for $500? You've beat what they're asking for, which is $200, but you didn't get $1,000. See, this is where the contract term of who's pays attorney's fees and what successful means becomes extremely important. I've been unfortunately in the situation asking a judge for reasonable attorney's fees when in that situation, it's difficult to tell. Like, Rob, your client won $1,000 on one claim, but is not successful in a claim against them for a certain amount of money, and then they actually are a net loss, even though they won technically their claim. They're at a net loss, so I'm not giving you attorney's fees under that contract provision. So at the end of the day, it can get pretty muddy. So, okay, fine, fair enough, whatever. What can we do about it then? What you can do about it is not just have that, if I'm successful, you owe me attorney's fees and court costs, is literally defining what success means in the contract. So you have an extra sentence or two that allows the judge to go, okay, this is definitive. Like, this is out of my subjective understanding of who won or lost. This is actually telling me how to calculate it. So let's go back to that example. You can write your contract in such a way that says success might mean, for example, where the parties were in terms of settlement negotiations before the lawsuit. That's success. If you beat that, that is success. Okay, does that make sense? So our example was you won $1,000 from the client for breach of contract, and the client is saying, no, I'll give you $200. I think I owe you $200. So there's $1,000 and $200. And let's say that is where the parties are before the lawsuit. If you have successfully drafted your contract with the definition of success in that way, where it's the position of the parties, but prior to the lawsuit, if you've done better, then that would mean that if you beat $200, you get attorney's fees. So again, I know this is hard. Like, I wish that I could have if you're watching this, I should have graphics, but I don't because I'm too lazy. And if you're listening to this, it's kind of hard if you're a visual person. But if you're asking for $1,000, they'll give you, they're saying, no, it's $200, and you're in court, and you have the appropriate language in your contract. If you get an award of $201 or above, then you are quote unquote successful and can get attorney's fees. Even though you didn't get the $1,000, you're still quote unquote successful if you've defined success correctly under that contract. I hope that makes sense. At the end of the day, even if you don't walk away from this podcast exactly understanding what you need to write in there, but at least you will understand I might not be fully protected with my attorney's fees clause the way it is currently drafted. And again, the reason why is because it's not always cut and dried having to sue to enforce your rights, having to sue and be successful in enforcing your rights, XYZ in this contract. What does that actually mean, particularly in the instances in which you've been sued back or countersued? So, however, again, what I would love to get across to you is that although these contract terms are super important and they should be in there, the general idea of your contract should be as a shield and not a sword. I don't want you to have your contract for the purposes of filing a lawsuit and suing somebody, although it can do that, and you should be able to do that when it calls for that. However, it should be a shield. I want you to use your contract in such a way that it allows you to retain money if the event is canceled or if the client otherwise materially breaches that contract. It puts you in a position where you already have the money, and it's easier to hold on to that money and go your separate ways rather than have to sue the client for money that is not in your hand. The contract should be a negotiating point and a shield rather than a weapon, a sword that you pull out at trial. I cannot stress that enough, that typically it is not the best for you to sue people for breach of contract for XYZ reason. You want to have your contract structured so that you don't have to do that. But if you do have to do that, at least have it to where it's powerful enough that you're going to get those attorney's fees. And if it's written right and it's powerful enough, perhaps that will get the other side to go, you know what, I will reconsider my position and give this to you because I don't want to have to end up paying attorney's fees. So I hope that has enlightened you a little bit about the American rule and attorney's fees and how your contract can get around that. If you have any suggestions for content for future episodes, if you have any complaints, if you have any suggestions, please let me know. Leave a comment down below or hit me up on Instagram. I enjoy getting feedback in any way, good or bad. Hopefully it's good. And thank you for watching. Thank you for making it this far. And with that, we will see you next time.
Thank you for listening to the Wedding Industry Law Podcast. This podcast is intended for general information only. Nothing in this podcast is intended to be legal advice. Do not rely on this podcast for your legal matter. Instead, consult an attorney in your area. Thanks, obrigada, até semana que vem.